Hello, everyone. Very nice to see you today, this a bit earlier morning for the conference. And so welcome to the panel on pseudonymity, automation and responsibility on a public permissionless blockchain under GDPR, organized by European Ethereum Institute. And my name is Veronica Hurina. I'm account manager at Flashman Hillard EU here in Brussels, advising clients on EU digital policy aspects, and today I will be moderating this session. So first, maybe let me give you a quick glance at what we are going to discuss here today. So we probably all know here in the room that GDPR was designed around this idea that someone should be in charge, either a controller who decides, or a processor who executes, or data subject who has rights. But then when it comes to public permissionless blockchain, we might not have a clear immediate answer from the start. So here then we gather together with these speakers to actually understand where does it leave us. And so, and of course, after our exchange, we'll also open the floor to questions from you. So let me first introduce our speakers. First, we have Viara Salva. She's a senior policy expert at European Ethereum Institute, which is a research nonprofit basically focusing on policy environment for Ethereum and Ethereum ecosystem in Europe. Then we have Amandine Jambert, who is a technology and cybersecurity officer at European Data Protection Board, also known as EDPB. And also she brings more than 10 years of experience as an IT expert from a French data protection authority. And then last but not least, of course, we have Andrej Kovarik, who is a former member of European Parliament from Czechia in a Renew group. And he notably was also a shadow rapporteur on a EU landmark crypto asset regulation, as we know, called MiCA. So thank you for all of you and welcome to the panel. And before we dive into debate, maybe first I will address the first question to you, Viara, and just to ask you from an infrastructure perspective. So all of us in the room, we have the understanding of underlying infrastructure. And could you walk us through, please, from how it actually works on a public permissionless blockchain like Ethereum once transaction is submitted? And why does this architecture actually matter for the legal questions we're here to discuss today?
Yes, thank you very much, Veronica, also for agreeing to moderate this. Thank you all for coming here this morning. I know it's pretty early and there hasn't been any coffee downstairs. So now I'll try to wake you up with a very, very intriguing discussion overview of what is a blockchain and specifically what is a public permissionless blockchain. So that would be your kick this morning. Hopefully it will work because we decided that not everyone needs to have already some knowledge on what the blockchain is in order to participate in this discussion and to fully comprehend the issues that are currently the focus. So what is a blockchain actually? And a bit about me first. So as Veronica said, I'm a senior policy lead with the EEI, the European Ethereum Institute, previously known as the European Crypto Initiative. My background is in human rights and technology, so privacy has been an enormous focus of my life. I wouldn't say just work, life. I've been working quite a lot on privacy compliance. So this is something that also for me is a very important topic, as I'm also doing a PhD on the topic. So yeah, feel free to then approach me and we can nerd out more about it, but I'll go more through the basics now. So it all started in 2008. We are fresh from the economic crisis, and there are people questioning the roles of centralized intermediaries, predominantly banks, because there have been issues that were made quite clear around that time that perhaps having a centralized intermediary isn't always the best approach. So that's when the blockchain, the first blockchain, the Bitcoin blockchain came to life, which was essentially a way to reintroduce the concepts that we are familiar with from the more traditional financial space, but without the intermediaries. So we have people being able to transact between themselves without those transactions going through an intermediary that is, for example, a bank. So that was more of a grassroots, let's say, response to what was happening and the reality of the economic system as it was. So how does it work? And I have a few graphs like this. Don't get scared. They're fun, I promise. So it's all based on cryptography, it's all based on math, and it's all based on economic incentives. So what you do is basically you have two people who exchange a value. In this case, we're only talking about Bitcoin, which is basically a blockchain that has only one purpose, which is transacting the Bitcoin. So the Bitcoin is the blockchain and Bitcoin is the token. So you have block-in, block plus one that always has the hash is always connected with the original block, and so on, so on, so forth. So you can trace everything down to the original block, and hence the blockchain, because this is a chain of blocks that are all interconnected, that are write-only, and you cannot intervene with that order by sheer will, or you cannot by, for example, being an intermediary, intervene because there isn't such a role. So each block embeds the hash of the previous, tampering becomes detectable everywhere and practically impossible. Hence, no need for intermediary. Two important qualities of this type of blockchains that are going to be important also for the further discussion we're going to have today. So it's public and permissionless. Public means the ledger is transparent and auditable by any observer. You can basically check all the transactions from any they're available online for any block analytics, and that ensures that everything that is happening is being auditable in real time. So you don't need to have like a specific external party to audit. And permissionless, which is also a very important aspect of this type of blockchains. Everyone can write, read, run a node, or validate. Node gatekeepers. Basically, this is an important distinction between public permissionless and private permissioned that we need to keep in mind when we're discussing blockchains, because basically when we're talking about permissioned blockchains, we're talking about something that is closer to a centralized database than to the blockchain as we perceive it more globally speaking in terms of blockchains such as Ethereum and the Bitcoin one. Because you have an administrator, you have someone who determines who can access, you have someone who determines what transactions are passed and what aren't. So you basically have a centralized database on a ledger, on a blockchain, but you don't have all these capabilities that what I just described, what the Bitcoin blockchain have. And there are all some of the important aspects. No administrator, mathematically immutable, it's all math. We trust math. We don't understand math, but we trust math. Trust globally replicated everywhere. So everyone has the same copy. And yeah, going back a few examples. So as I said, permissioned, centralized. It's more of a database. There are some examples that are particularly used in the context of banking. Banks do indeed need to have very often, and not just banks, also healthcare providers, basically more centralized services that also need the security and also the predictability of the chain, who can add what. And they're often structured as consortiums, and there are some examples underneath, and they do have their function in the world. They are important, but only in very specific use cases. They are not what we call public blockchains, that are these distributed networks that all have the copy of the same ledger, basically, such as Ethereum, Bitcoin, which is basically the focus of what I'm going to present furthermore. Ethereum enters the space, launched in 2015. Basically, what differs it from previous iterations, like most notably from the Bitcoin blockchain, is that it's created as a world computer. Basically, you can integrate different functionality based on smart contracts. I'm not going to go into the technical details of what smart contract is. All you need to know is that a smart contract is not a contract in the legal sense. If you learn one thing from this talk, smart contracts, not legal contracts. Lines of code, not the same. Launched in 2015, currently around 1 million validators. Basically, those are the entities that make transactions possible. They literally validate the transactions. and it takes 12 times for a block to emerge, new block to emerge. Each block has the information from our previous block, so it's a blockchain again. So those numbers are important, especially the 1 million validators, especially for the further discussions. And how a transaction works, and I'm finally coming to your question, Veronica, sorry. You have wallets. So a wallet is something quite often perceived as the place where you store the crypto. No, it's actually the place where you store your public and private keys. So cryptography 101, you need a public and private key to validate, to sign a transaction. You have the network, you have the role of the validator that verifies and includes the new block to the chain. Then it's added to the chain, and then it's visible. So, and what is critical is you always need a wallet address for this to happen. Basically, the wallet address is your public key, and then the private key is used to sign the transaction, and then you have all of this visible because it's how you then audit, quote unquote, that the system is working. But all that you have is this random for us, not for machines, but combination of digits and letters. So this is all that you see. That's the address. So here are two scenarios, and we're gonna go deeply into them. I'm mindful of time as well. CASP. A CASP is something that Andre will likely talk more about, so I'm not gonna spend that much time, but it's a regulated entity under the Markets in Crypto Assets regulation. So CASP is a crypto asset service provider, and in this case, you have actually the centralized entities. So this scenario is when you don't have it, when everything happens on-chain without an intermediary. So you have, for example, I am the user who wants to send Veronica some ETH. ETH is the native crypto asset of the Ethereum blockchain. So I enter my decentralized wallet. So it's a peer-to-peer transaction, basically. MetaMask, I have the wallet address as basically this OXX7A, for example, yada yada is my wallet address. And then I either send it directly to her wallet address, that is also some variation of letters and words, or I go through a DEX, that's a centralized exchange, where I can also exchange it for other crypto assets. And it goes through a validator. Every such transaction goes through a validator. So that's what happens, and basically it happens automatically through smart contracts, not legal contracts, again. So no identifiable intermediary holds a mapping between my wallet address and basically all that, and me, basically. However, if we have a crypto asset service provider that is a centralized entity, we then also have an entity that has collected all the information necessary for onboarding a user, which if you have onboarded with a bank or a financial institution, you know what that means, KYC, so all those documents provided, so then you are very clearly identified. And whenever such a transaction happens, for example, I'm a user, I'm onboarded with an exchange, big exchange, not to name names, and then actually they are custodians of my crypto, so I'm not holding it anymore. And then they also have all my all my information, so they are also the data controller in this case. It all happens on-chain, but it's then connected with the off-chain information, that is my identity, and the validators and everything works as it is. But it's connected with the hosted wallet by the exchange, not my unhosted wallet. So something important in terms of that, public observability, basically that we all can see the transactions happening and the specific wallet does not mean universal identifiability. And here it's a bit of a spoiler to also what will be presented with the EDPB guidelines. There needs to be this distinction, and that's why I have it as a separate slide, especially when it comes to requests to delete the whole blockchain, as I just highlighted. That's also impossible to do. So important to also keep that in mind. This one?
Yeah, thank you.
Yes. Let me know when you're done. Yes. So going more into the details also of the technology, so Ethereum. I'm part of the European Ethereum Institute, so I can talk more about what the Ethereum Foundation and the Ethereum ecosystem is also building, because this public visibility of transactions and the public visibility of wallets has also not been considered as something ideal by the ecosystem. So there have already been works done towards making either the transactions not visible or the wallet addresses somehow at least more private. I'm not going to go into all the technical details. I just want to highlight that this is ongoing work, more also from, on the one hand, the legal side, but also from the technical side, because this public visibility of transactions has been considered to be a problem also for the community in certain circumstances. So the technical developments should also be acknowledged. I will broadly speak about privacy enhancing technologies, but under that umbrella term, we have things like zero knowledge proofs, fully homomorphic encryption, and so forth. But I wanted to highlight something that recently came out from the Ethereum Foundation. If you're curious, you can look for the mandate, Ethereum Foundation mandate, and it's talking about CROPS. Censorship resistance, open source, privacy, and security as the core fundamentals of what is going to be built on Ethereum. And privacy tools, and here it's again, if you're a cryptographer, I know that this is not necessarily reflective of all the privacy tools, but also even yesterday, Vitalik Buterin, who is one of the creators of the Ethereum ecosystem, posted about privacy, the importance of privacy. So, for example, this key nonsense that I'm not technically quite aware of is also one of the things that are now also being integrated in the chain. But what we have, Kohaku, is a recent update of the blockchain that is also basically intended to hide your IP address from the node providers, and other updates stopped validators from censoring transactions and so forth. That's more of the censorship, but they're all intertwined. And something important to also acknowledge is the work that is happening outside of the GDPR, because obviously we have the notion of what personal data is through the GDPR, but we also have other notions such as identity that is currently being developed through the ADAS2 framework, the digital identity wallet, where they're also calling for more ZKP, zero knowledge proofs, to be integrated and other such mechanisms for protecting the identity of users. So those are very critical, and also the community is working more on the technical side of that. So that was a very quick and dirty explainer. We'll have time for questions, but I think that sets the scene also from the more technical point of view of what we're gonna discuss. And yeah, thank you for the question.
Thank you so much, Piara. This was very insightful. So now coming to you, Amandine, we all know probably that now EDPB is finalizing guidelines on processing personal data through blockchain technology, after also consulting on it last year. So for us all in this room, what would be the most important maybe points for all of us to take away from that?
Okay, good. Thank you very much. Thank you for inviting me. I said technology expert and cybersecurity officer. To be completely fully transparent, I'm also a doctor in cryptography. So just, the mathematics are super, super nice. And I did my thesis on zero knowledge proof. So yeah, now I did the full transparency part. So if you have two nerdy questions, I should be able to answer some of them. In any case, there is one part that is super important and are reminded in the guidelines, is the fact that a technical impossibility cannot justify not to comply to the law. And I think if there is one thing to remember today, is that, okay. But it doesn't mean that you can't do a lot of things, because we have amazing company and amazing cryptographer in particular. And so you have a lot of innovative way to do things, to do what you want to do. It's just that sometimes you cannot do it how you thought you will do it initially. So we work on the guidelines about blockchain because, yeah, we have more and more blockchain that are used in various contexts. And there are a lot of friction between GDPR and blockchain. From what just explained, you can see the point of immutability, the fact that you cannot change things. You already see that there are frictions there. You also have the fact that it's completely decentralized. So you already sense, as at CPDP, I know you are all privacy specialist, so you already sense that there is something behind that. So the idea of guideline is always your guideline from the EDPB are only by default regarding GDPR. It doesn't mean that we ignore the other law, but it's our field of competency. So by default, and I say by default because more and more we are working, for example, with the Commission to have joint guidelines, but by default, guidelines that are EDPB or joint guideline EDPB, EDPS are only regarding privacy laws. So what do we say in those guidelines? I will let you look at them, but we have different parts. We will talk about most of the hard points. And if you don't have time, just do one thing, look at the Annex A. There is a 16th recommendation. It's just a few pages. So if you don't have time, just read that, I would say. They were published initially in April 2025, and there was a public consultation until June, and we received 150 comments. So it's the most, the biggest number of comments we ever received. In practice, we identified that a lot of people had the same issue, so probably there was a group of persons sharing their worry together and sending individually the thing, but it doesn't change. We take all of them into account, and we take into account the fact that a lot of them share the same problem. So we are working now at taking all of this on board. In fact, even today there is a meeting of colleagues working on the future consolidated version of the blockchain guidelines, and those there will be a new version soon, but never commit on the date. So, okay, what does it say? I think the most important and first point is documentation, and that is super linked with transparency. Blockchain is just a technology, okay? It's a technology with a lot of advantages and a lot of cons, okay? A lot of things that will be super tricky. So it's very important that you think through before choosing blockchain, before choosing a blockchain in particular. Okay. First question, and we will talk about it later, is will you need to have personal data on the blockchain? Super important first question. Second, if so, why do you need a blockchain? Is it necessary, proportionate to use, like this kind of tool? Why do you use it? Is it in line with your purpose? Blah blah blah. What type of blockchain should be used? Because yes, today we are mainly talking about public permissionless blockchain, but that's not the only one. And then what technical organizational measure are you going to put into place to ensure that you are respecting the law, because it's mandatory. So, okay. So we have had the explanation. We have seen that in the transaction, you had the public key of the person sending as a transaction and the public key of the person receiving. So it looks garbage, but it's a public key. So it can't be more linked to an individual. It's already a hard identifier, because everything that you will sign will be verified with this public key, okay? But you also have, so in the example that was given, it was the amount, but the amount can be, you can have more data than just the amounts. You can have what we call a payload. So the payload can be a lot of things. So we have example, for university, and we had university who wanted to make their diploma verifiable everywhere in the world. And so in the payload, they put something. So it could be the diploma, but they were more clever, so it's not exactly how they did it, but you could put there in the payload an information that will be then available to everyone, visible to everyone on the blockchain, and so verifiable by everyone. And as these payloads will be in transactions that come from the university with the public key of the university, then everyone knows that it's this university who, put the diploma of Amandine Jambert on this blockchain. So you can be sure that I have the diploma I'm claiming to have, okay? So this payload is quite important because it's one more area where you could have personal data, okay? So you can have personal data there, you can have personal data in both sides of the identifiers, the public keys. I say sometimes because it could be organization. And so it's more or less the three points where you could have personal data. But why you might have personal data, it's not always mandatory to have personal data. And that's your first question with that. And it's the first thing that the EDPB guidelines say is if you can do it off-chain, please do it off-chain. Because the blockchain comes with a lot of advantages, but with a lot of complication whenever you want to comply with the law, and especially with all the law about rectification, data retention, erasure, and so on. And you already see that you will have tensions there. So if it's not needed in your process, then just keep the data off-chain, and maybe there will be other things that will be interesting to put in it. But if you're here, probably you want to have something linked to personal data. So then, second step, can you keep the data off-chain and have just a link that is on the blockchain? So it can be, for example, a pointer or something. You know, like you have the data that are outside, and you will have some kind of URL or something that does not contain personal data that will be on your blockchain. And so, good thing is if you delete the data on the server, that is simple web server, then the information doesn't exist, and you will just have a URL that goes nowhere on your blockchain. That saves you. But in some cases, even that is not possible. And then you have the third possibility, the last resort, I would say. In this case, cryptography can save you. And I'm not saying it only because I'm a cryptographer. So you have more or less three possibilities. I would say the best one is what we call commitment, cryptographic commitments. That's a super, super nice tool. It's used in zero knowledge proof, typically. And the idea is you can hide a value in it, okay? And you will have what we call a witness. So you will have your value, your witness, and the commitment you're doing. And some of those commitments that are what we call perfectly hiding will perfectly hide the information upon it. And it hides it so well that if you don't have the witness and the data, you could have hidden in it probabilistically everything. So the day you delete the data and the witness, you don't have any personal data in the commitment, okay? So that's the best. If you can do that, that's amazing. When I was talking earlier about university, it's one way to do it. You put a commitment on the diploma, then you give all your students the witness, and they of course have their diploma, and they can give witness and diploma to their employer, and they can check on the blockchain, no problem. And the day they want to stop it, no problem, they just have to delete the information that are off-chain. You can also look at strong encryption, or you can look at hashing with a secret key. The thing is, encryption is a little bit, is super strong, but a little bit less stronger, especially now that we are talking about post-quantum cryptography and this kind of things. So we do know, I hope it will be in the far future, but we do know that the cryptography we are using now might not be the cryptography we'll be using in 10 years. And so you might have here again some kind of tension in what you can do and your data retention. Okay, so that will be the three points, is how you put the data. And that is completely agnostic of the kind of blockchain that you will be using. But in practice, you have more or less for a family. It's a big caricature, but that's true. The easiest one is a private permission one. But to be honest, if you have a private permission one, in most of the case, you do not need the blockchain. But it does exist, and it's easier because you are controlling everything. Maybe you just need a very good, cryptographic tool in-house and not blockchain in that case. But anyway, it's here. And Sadly, the highest risk is public permissionless blockchain, because everything will be online, everything will be visible by everyone. You will have a limited impact on the decision that will be taken by the one who will be the validation and so on. So it will be the one that will be the highest risk, and so the one that will require you to think about it the most. And depending on the cases, you will have different role and responsibility. And there is one part that is super easy, is if you are the one deciding to use blockchain to do something, then you're a controller. Okay, so that's easy, obvious for everyone. Okay, and then there is a less obvious part. Yes, okay, but what about the validator? Okay, this question will be case by case, because in those different cases, it will be different. Depending on the implementation, it will be different. Typically, if you have a consortium, it's the easiest. Why the bank are looking at it? Because the consortium can have a legal persona, so they can take the responsibilities, they can decide on a lot of things and so on. They can be controllers. Okay. If you are not thinking about it at all, and you end up having validator processing personal data, then you will have to think that there is two possibilities. Either they are your processor and you need an Article 28 contract, or they are controller of personal data, and then they also need to comply to the law. So you have a lot of thinking to do it, and so that's tricky. And so we come back to first rule: if you can, do not put personal data online on the chain when it's a public permission blockchain. Okay, I will be super fast on the other point because I think it's the main one as this one. But what we are talking in the guideline is the fact that privacy by design by default are your first thing, because as blockchain are immutable and do not change after, everything that you will have done before will, help you. So do it as soon as possible. I think it's one of the most important points this time. You have to think about data retention periods. If it's not possible for you to have data for as long as the lifetime of the blockchain, then maybe you don't want to put those data on the blockchain in a way that you cannot delete them. Minimization. Minimization is, like a classical thing. So you have to minimize personal data you put, but both on and off chain. But I think you are legal professional. I don't have to teach you about that. You need to inform people. This is not something that needs to be said more. I think if I want to take a little bit of time on some things, will be the two below. I would say. You have to limit algorithm failure. You have to think about the fact that, blockchain is cryptography, but cryptography is evolving. When I started my PhD thesis, people were using hash functions that are called MD5 and SHA-1. Both of them are broken now. Okay, everyone are using new name and function. Maybe in these rooms there are people who even don't know what MD5 is. Okay. And that's completely normal because it's crypto, and crypto we are working all the time. People are building bigger and bigger computers, and they are stronger and stronger, and so things are evolving. So even if it's just from a crypto point of view, you have to check and ensure organizationally or technically that things are manageable in the time. But it's not only that; it's also its software. Okay, and we know now, especially nowadays, with all the AI doing cybersecurity stuff, that vulnerability exists. Everyone is doing what they can, but nobody has a perfect shield. Okay, so you might have in the future a software problem, a software at the client level, or a software a problem in the protocol that is lying on. So you have to think it through to be as resistant as possible if it's important for you. And then can be done a lot of ways, including, by certifying, auditing regularly, being up to date as much as possible, and so on and so on. And then second thing, data subject rights. this is super, super hard when we are talking about blockchain, because it's not because it's on the blockchain that you don't have to provide them. So if it's public, it's super easy for right of access. You can have access to it, good. But when we are talking about right to be forgotten, right to rectification, right to object, how we have a problem, okay? So it's really something that have to be synced through before, again, privacy by design. And if by design you plan that it will be okay and it will be possible to delete and modify the information, then you will be good. And this is linked to one thing that is super, super important. As it will be super hard in any way to withdraw consents of information that are written in the blockchain, please, pretty please do not use consent. Okay, so we have a lot of those are legal bases. Okay, all legal bases are born equal in the GDPR. Okay, so please use another one, because if you are using consent, then the problem is one day you will have user coming and say, I want to withdraw my consent. And how do you withdraw consents on a public permissionless blockchain where the information stay? Okay? If you have committed, okay, you can delete the information or flag the witness. I give you this one. But in other cases, once it's written, you are stuck. So you have a lot of legal bases. I'm sure another one will be perfect for what you are thinking. Last point, super, super tricky one. Blockchain are quite often, like spread out in the world, and we are talking about big ones. They often are a little bit everywhere in the world, and it's not because it's blockchain that you don't have to comply with transfer. So you have to think it through also. Maybe one more reason not to put clear text personal data on the blockchain, but else you have to find a solution. Okay, so you have to think it through. For consortium, for example, I know that some are thinking about how they can put contractual type clauses or such kind of things. But if you are on a public permissionless blockchain, then the group behind it have to agree in a way or another, and they have to find a solution together. Okay, and to ensure that it works. And I will just finish on this. It's just a tiny point. You know how EDPB people will love DPIAs, and I just wanted to remind you that it's a new technology, an awesome one, but it means that typically you already have one criteria out of 9. And so it will be super, super often that you will end up aiming to do a DPIA when you are using blockchain, okay? Doesn't mean that it will be all the time, but it will be super, super often the case because you can quite easily have either a processing with a lot of people, or you might have some kind of data that can be a bit, important, or you can very, very easily ended up needing to have a DPIA. So if I could advise, it never hurts to at least ensure that you have the time to do a DPIA, even if you don't need to do it at the end, if you are thinking about using blockchain in your text processing. And thank you so much.
Thank you so much for this presentation. And then now moving to you, Andre. So as a former member of European Parliament, you spent years basically working on the intersection of digital finance, crypto asset regulation, and privacy. So from your perspective, would you say that the current direction of a travel of this blockchain and data protection debate is actually coherent with broader EU digital ambitions?
Thank you for that. I will spare you with the presentation because I think this is more a point for discussion. But thanks to Viara and Amandine about presenting their points of views. I think they're very very useful. First of all, I'm really glad that we are having this debate, right? As a former policymaker, I was always trying to do, and the members of the European Parliament at some point decide basically on laws in different areas. So we're talking about digital sector, we can talk about financial sector. specifically the crypto asset services, but also data protection and privacy measures. And I think what was always the most challenging in all of it is actually to be able to reconcile properly all the policy goals, so that like the legislation that is adopted and then to be transferred into practice is actually workable from all points of views. And obviously we have a lot of principles in terms of like the very basic policy principles that we would like to follow in the European Union. And I think, well, data protection and data privacy is definitely one of them. That is for sure. But also we have other policy goals that we are trying to push forward in the agenda, such as support for the broader use of technology, innovation, startups, community, and et cetera, et cetera. So I think it was always challenging to find the ways how to put these things together. So first of all, I'm very glad that we're having this debate on this particular grounds. But like maybe to start a little bit to balancing the debate, I think that the debate is actually quite late. I think we saw from Viara's presentation, we had like the first, let's say, really global presentation of blockchain technology in the form of Bitcoin, introduced in 2008. The Ethereum network has been co-founded in 2015 and launched. It was, well, started a bit earlier. The GDPR rules are in practice for almost 10 years now. And we only got the guidelines in 2015 on the use of blockchain. And I get the argument that the European Data Protection Board actually only came to this issue because obviously there's now broader use of blockchain in general. But I think, like personally, I would like to see this debate actually happening much sooner than that, even before the blockchain technology becomes more widespread in use, because I think the clarity about the rules and predictability of the rules is something that is actually very useful for, first of all, meeting all the policy goals that we have at the first place, and then second, actually to allow for technology to be adapted to it. And then I have to say I fully share Amandine's views on the fact that there's a lot that technology can do in order to protect privacy and comply with the rules as formed by GDPR. So that's one of the remarks I wanted to make first. Then I was dealing with the crypto assets regulation since more than 6 years now in Europe, even then when it was actually not a real topic. We were a handful of us in the European Parliament dealing with it, and some other people were just not really getting what we are discussing. The European Union became one of the first global jurisdictions to have a truly comprehensive legislative framework on the crypto assets service provisions. But I have to say that like basically all the time dealing with this, no one from any institutions actually came to see us to raise the concerns about data privacy. And I think I'm not saying as a complaint, I'm just saying this as a matter of fact. And so there was a lot of people engaging with legislators and regulators from various points of views, technology, financial, and even like security and obviously some criminal law aspects. But data protection has never been mentioned, and I think it should have been as well on our table. And I think maybe there's one remark that I wanted to make, just maybe to highlight, because basically what I'm trying to sort of make a point here about is that we should really look into policy coherence when we approach anything in European Union, and I think this is just one of our weaknesses that we have. But just yesterday, the European Commission launched a public consultation on how the rules on crypto assets can be reviewed in upcoming period. Just not only because there is a deadline in the framework that asks the Commission to do it, but also I think there's actually very fast-paced technological and I think also industrial developments that the Commission is trying to react to. The public consultations, the targeted part is over 40 pages long. It has roughly 85 or over 80, up to 90 questions to be discussed with the industry. And guess how many of them are actually touching the point of data privacy and data protection? It's exactly 0. There's only one question at the end of the public consultation, 85, which asks the industry to develop on any other legal aspects that can be attached to the provisions of crypto asset services. And I'm just using this as an example again, like how the policy coherence is not working on this level. And I think, again, coming back to my experience as a member of the European Parliament, very often we come at some point of the process to work on the specific legislation or the policies. But I think if the coherence is actually not there from the very beginning on the institutional side, it's that we are missing some of the points. And this is also just to make the point that, I mean, if we don't have it on our side as a regulator, supervisors, and the policymakers, it is actually not extremely legitimate to ask it, by default from the services providers, because they actually don't know how to comply with all the rules that they have. And I think, this is definitely something that we should improve. And if debates like this can help that, I'm only glad. If the debate that the European Data Protection Board launched with the public consultations and the guidelines and the work on the guidelines would contribute to that, only better. But I think we really need to improve something here. Then, when I was dealing with this regulation and talking to crypto industry, I think what struck me quite a lot was that there is actually a huge concern about the privacy in general. And I think also this is what Viara described in parts of her presentation. And to be honest, when we actually were designing the regulation and the crypto providers were looking into it, one of the main concerns from the industry was actually we are breaching the privacy rules or we are actually somehow violating the privacy rules that are already in the blockchain systems by default, because we want them to open them to public. And there is one of the concerns that is, again, how to reconcile the public interest. As long as there is a number of financial operations happening on the blockchain system, there is actually another piece of legislative framework that is entering the game, and that is the anti-money laundering and counter-terrorism financing legislation, which, on the other hand, asks those who are running and providing services on any kind of financial network actually to be able to communicate if need be, but also on basically need to know, but also on a continuous basis, a number of data, which part of them are also private data on the transactions. And this is all to prevent, or if need be, then to investigate whether the specific financial system was used or misused for illegal or illicit purposes, for cases like financing of the terrorism or money laundering. And this is also something that is very critical. I haven't seen that in basically any of the presentations, but I think, Viara mentioned it I will come back to it for CASP's obligations, so those gatekeepers for the financial provisions. But again, I think this is something where if we have on this very panel, for instance, a person from any kind of financial intelligence unit, or newly created European authority called Anti-Money Laundering Authority that has started its action this year. I think we will also have yet another perspective of how they need, for their own purposes, some of the data that are processed through the systems. And I know that the AML framework is always somehow reconciled with the data protection and privacy framework in Europe, but I think there's some specific use, such as blockchain, again, put a number of new challenges to all of it. So again, I think this is something important that we should deal with. And I think, as I mentioned, the obligations of I think some of the specific entities that are in this specific period of time, I think the most used in the financial system working on the blockchain networks. That would be the crypto asset service providers, which are since basically early 2025 in the European Union now obliged to request and operate only with a specific authorization on the European market. So I think that this is an important point also to make sure that there is actually a number of entities, mainly those entities who provide the critical mass of financial operations, that are actually centralized, and that would be in terms of compliance much better accessible, also from data protection compliance from the supervisors to see how and by which kind of structure, procedures, and operations they comply with the data protection rules as stated in a GDPR. Maybe one final remark before we kick off for the debate. I mentioned that we obviously have data protection and privacy as one of the key foundational principles that we reflect in many of our legislative frameworks in the European Union, and I think rightly so. At the same time, we see that the reality, technology, and also the policy frameworks are evolving, and we sometimes are actually testing the limits of the legislation that is in place. And I think it is also fair to say that I think on one hand is the principle and the basic rights that we are trying to protect and preserve, and on the other hand there is a practical legal framework, and then the practical implementation of that legal framework. And I think those things are not always playing very well together. And that's also why I'm glad that we have this debate, because I think without actually compromising the basic principles, I think what we see here is that sometimes the practical implementation and the way the framework is designed is actually not fully meeting the needs of the technological development as we see. Quite recently, there has been a decision on the level of European institutions regarding the use of also some of the private data for the purposes of artificial intelligence development and research, which was a sort of a reaction to the fact that the development of AI in the context of GDPR again had some practical challenges in the way it was implemented. I think we will now discuss the rules on how the crypto assets services will be provided in Europe through the review, etc., etc. I think it would be actually also valid to test the accuracy and proportionality of all the rules that we have, to what extent they can actually be fully implemented. And I think I really like these 3 points. By default, store off chain. If you can't store off chain and make a link. And then if not possible, make sure that everything is done on chain in a compliant way. I think this exactly should be the principles that we should also look into when reviewing the legislation in many areas. But I think at the same time we should look at it from the point of view of whatever we design as a framework should be open for any kind of future developments. As we speak right now, we are talking about the blockchain used to Bitcoin and Ethereum networks. But I think what is actually happening in reality is it's much more than that. The Ethereum blockchain network is actually becoming an underpinning technology rather than a specific let's say financial asset to be traded. On top of that technology, we actually see an extremely fast pace of emergence of a new sector, which is basically one of the elements that will be seen in practice is actually AI agent in commerce, which is basically a very fast way of trading of anything on internet. Which will be underpinned by atomic settlement. So basically financial transactions happening online with a very quick pace, with no intermediations in between. And these atomic settlements will be basically based on a financial asset called stablecoin, which is one of the types of crypto assets token that is basically until now running in majority on systems that are public and permissionless system to connect them. So I think we see that the reality is again much more advanced that we have in our policy frameworks. And I think it would be very wise because these things are happening. It's like Amandine, you mentioned the post-quantum. It's gonna happen. We know it's gonna happen. I mean, you said in a decade. I would even say, I mean, this can actually happen before the end of this decade. It's happening very fast, and I think if we know that things like that will happen, let's actually make wise decisions, and let's already today try to adopt frameworks that will be adapted to the situation that we know that is coming in the years, so that we don't have to come back and reiterate all sort of decision making process once again, because we realize that we are not fit for the moment. I mean, it will never be easy to get to the same pace of the technological advancement, but I think what we can do is actually have a smart type of regulatory and policy work that will be able to sort of foresee what is coming and trying to react to it as well. So that I think would sort of conclude my remarks, and happy to have broader discussions on that. Thank you.
Thank you so much. So now we also have a short kind of a round of follow-up questions. So Amandine, first coming to you. So as we already discussed, that of course the whole definition of personal data and GDPR was defined and designed with this idea of identifiable individuals in mind, where but then, for example, Court of Justice also established that would also depend on specific actor and also realistic means available to the specific actor. So, and then when we look at the public blockchain, the protocol itself might be designed to the fact that it limits what actual participants can see or do. So the question is here, how would you say this assessment should work actually? And would you say that the current interpretative approach actually reflects it in reality?
Thank you very much for this interesting and not so easy question. But first, I have some points that I would like to jump on what my colleague said. One says is, do not worry when we said deleting the chain. If it's not compliant, it was a reminder of the rule like DPA are not planning tomorrow to come to the blockchain and ask them to delete. Like that's one thing. It's just, if you do not complete the rule, it's a risk, and we needed to remind you of the risk. That's one point. Yes.
Yes, if I can really quickly, I understand that you have the best intentions and that you in particularly and the team drafting the guidelines do know this, but let's keep in mind the context of the guidelines. Basically, their purpose is to explain the GDPR predominantly for EDPS, the data protection authorities on member state level that do not necessarily have all this knowledge. So at the end of the day, when facing a case, they do not have the capacity to make this kind of, all this kind of trains of thoughts leading to the conclusion that we can't ask them to delete the blockchain. They will read the guidelines and be like, okay, there is a solution here in the annex. They're saying delete the blockchain, so we can go out with our decision and say, by the way, you need to delete the blockchain. That's what I'm saying, and that's also in one of our one of the 150 responses is ours, basically saying we need to clarify this because the intended audience for those guidelines might not necessarily have all the knowledge. So we need to add more information to actually make this clearer.
I agree, but what it was a reminder of the risk. It's the highest risk, and I will say it's the atomic bomb of the DPAs. It happens. You know, like all of you know that it can happen. It happened in the past, but I think, you know, the number of time where a DPA requested for the complete stop and deletion of an entire process in the architecture is super limited. If it's in all Europe, we have 100 of them in the last 10 years, I would have been super surprised. So what I mean is, it's an atomic bomb of the thing, but it's still possible. But I mean, just I wanted to reassure a little bit because I remain this. And I on my left, I also one part I wanted to share is yes, I know we are you know, like slow in our process. I know at least 2 DPA provided elements about blockchain in 2018. At least from top of my head, I think it was Hungary, but I'm sure it was France, at least, because I was in France at that time. And so there was thing, and I'm super sad the parliament couldn't have access to people, you know, like talking with it, because we are, you know, like regularly working with the commission. And we are very happy with the work that we are doing with the commission on this. And that's one thing that is super important for us, and that we are pushing more and more, and you have seen it in the last months and year, is we are doing now a joint guideline with the commission to have things that are, you know, taking into different aspects, like we have ongoing work on AI Act and GDPR, this kind of interplay. We have done it for DME and so on. So I hope in the future we will have even more consistency, and that even the parliament will be able to find our colleague from the EDPS and else from EDPB to be able to have, you know, like our first idea as soon as possible when you start to have this discussion. But then, you know, in any case, you had a question, and I hacked your question from start, so sorry for that. So your question was about personal data and how identification and all this. So first, if you have a processing, okay, and the processing happen, and then you have a user and you are not in one of the exceptions, and you are targeting, you know, targeting European residents, then you have to apply the law. And, you know, applying the law is not, you know, like an option. So then you have to think it through. There is one point that is important, is if you are a controller and you are sending information to someone, even if the information are pseudonymized, okay, they are working on that. And Scania said, so we have one of the cases that said that's okay, but if the information are identified, so we have two things. SAB say, if I'm controller and I say these information, then I have to do my job. And so I have to pick wisely my process, so on and so on. And you have the other way around, is if I don't know what the information are, but I am sending it to someone who is able to know who this person is, then we have Scania that say, okay, so you know also. So yes, you have in SRB 100% this question of perspective. That's a lot of our work nowadays. We are redrafting once more the guideline organization to be sure that it's super clear how you take into account SRBs. So yes, you have this question of you are looking at the different perspective and so on. That's true, but it's still not a free card, I will say, because you will have different points, and the problem in a transaction is that you usually have your two endpoints who very clearly know to whom they are sending something or who is sending something to them. And that makes it not so easy. So then you have a lot of solutions to ensure that it minimizes the middle, but you still have this tension that will exist because of those two ends that will be super clear for the sender and for the receiver. But at the same time, you can pick a nice way of implementation to limit your problem.
Okay, thank you. And then maybe coming to Viara, what would you say? Does it really matter where in the stack you are? Let's say if you are a user or you are a deployer, what is your thought on
Yes, so it should matter, and I'm really, really thankful to both the co-panelists for raising important topics that I will now build upon. So one of the things is, I'll start by the overlap with MiCA and the AML. Again, very important, those are already regulated services, regulated market, and the market that depends on public permissionless blockchains, because the crypto assets market that is regulated is basically based on public permissionless blockchains. So we need to figure out a way to make this work. Also because it's not just because it's a very interesting topic, but also because it's already integrated into our existing financial market. And something that also touching upon your question on infrastructure and what Amandine said, those two ends, those are the wallet addresses, the ones that basically the wallet addresses that are transacting.
Or your smart contracts.
Yes, but that is always something that is making some sort of a new entry on the blockchain, and that is connected to something that, for example, the guidelines are already pointing as personal data, which is what we, for example, consider to be quite problematic, because this means that any interaction with the public blockchain would be considered data processing, which in practice this would not work, because we care deeply about data protection. I can tell you, I personally care about that. And the most important part about data protection is actually being able to pinpoint a party that is responsible and that holds the data. It's not just like the existence of some possibility of someone processing data. So the clearest cut would not be to go after all the validators and all the operators that have some interaction with wallet address or smart contracts, which is currently in the initial version of the guidelines. We'll see what the end version would be like. But it's to actually go after those entities that possess the information that would lead to the identification. That also leads to the SRB logic, where the responsibility starts, where you are actually able to identify a person. It doesn't start on you having some streak of letters and digits that might be linked to a person in some capacity, because then you cannot really comply with that. Who is going to comply with that? One of the 1,000 validators? It doesn't make sense, unfortunately. So we need to go a few levels up and go to the services that are being provided by the centralized entities for which the GDPR was drafted in the first place. And that also brings me to the another topic that the highest risk, as you also saw on the Amandine slides, is the public permissionless blockchains. And then we cannot really say that those are agnostic guidelines per se, because they already limit the usage of a technology. For example, the consent, as we discussed, is not possible as a reason for data processing, but we also do not have legitimate interest also based on the guidelines. So we are limited in a sense. We are kind of discriminated upon just because this technology is being utilized. And this is a very big problem, because we need to fix this, because it's already utilized also by other regulations that are building on the concept that this technology is used. So yes.
May I? I'm sorry, but I think the problem here is because blockchain, public permissionless blockchain, was initially designed to go around regulation and to be something that is outside of regulation. So of course, they arrive at a time now, they want to be used, they are completely, like a nice company trying to do their best and so on. But they started with something that was not designed to be, like compliant. But the problem is, and I understand your problem, but it's not because, guidelines don't, like the GDPR is agnostic. Okay, it doesn't care about the technology. But then when you apply GDPR to a problem, you can't say, the way it's written and the way it's done now, it's yet not enough for you to do it easily. It doesn't mean that you can't do it, I'm not saying that. I think that it will require a lot of work. When I say high risk, it doesn't mean that you can't do it. It's high risk means high work, okay? Low risk means lower job, okay? So it's really this point. It's a problem. It was designed to work without, without the main authority, without trusting each other, because it was that the idea, blockchain behind was how we do a system where we don't have to trust anyone. We don't have to give the power to one person, we give the power to everyone. How we deal with that? So of course, when you arrive in a situation when you need to all agree together to choose, I don't know, like a legal basis, a consortium, a contract, or anything. Then it's hard because it was designed to be different. But it doesn't mean that it can't be done. And we have every day example of completely decentralized situation. We are all using email every day. Email is completely decentralized. All of you, or I mean most of you, have different servers. You have different providers. We are still able to apply GDPR to it. It's completely decentralized.
So maybe perhaps
There's
we
an
can focus in the guidelines on how to make it work rather than just listing the reasons why it won't work. I think that would be...
the problem is we are not there to force you on one solution. And we are sure there are a lot of different solutions you can apply. And we even give some. I mean, we hint about some of them. But at some time, as you said, technology is evolving all the time. There are new ideas every day. We are trusting the EU environment and our researcher and organization to find a nice solution and to be compliant.
Yes, thank you so much, Amandine. I just also wanted to give floor also to Andre to say his thoughts on this topic. Yeah.
Well, first of all, to be honest, I don't buy the comparison with the email. Email is actually, compared to the blockchain, is heavily centralized. So the way you access your email, you have always a gatekeeper. Email is not different from anything we do on internet to exchange data. Okay?
You have a different address, domain name, and different servers and so on.
Of course, but that's how we exchange data in any other types of. It's like you exchange data in your internet banking. It's the same thing. I think it is. And then I think what is different here, it's the underlying infrastructure. And I think this is what we are trying to explain. That the way the blockchain is functioning, it's different from the way that the regular internet is functioning, the Web 2 that we know it. And I think this is what we should look into in terms of trying to apply the rules that we have. Okay? That is why we don't care. If that was the case, then we would have to discuss the regular financial transactions that we know today. But we don't discuss them because they are clear, right? The way you access the financial services through your banks, it's always the gatekeeper, etc. So I think this is something that is clear. But for me, what would be really interesting to know also, and this is like, because I haven't heard that until now, how in your view or the Data Protection Board view, the privacy compliance on one hand can be sort of reconciled with all the AML provisions, because obviously I think we also struggle a bit there. On one hand, to delete or keep the data off chain or to hide them as much as possible, but on the other hand, to be able to let them be seen and communicate them to the specific authorities on this purpose. And it's not only under the criminal law. The AML provisions are much stronger than that. There is a lot of ex ante reporting on the transactions, and I think if we don't provide the complete information, then obviously the AML provisions would not work. So how would you see this? Actually, this is something where I think we will hit somehow the limits of the debate in the practical policy making, but also in the implementation afterwards.
So in two steps. The first, we heard it. We had in the public consultation, a lot of people were worrying about it. That's
why I'm raising it.
I know. So the final version will be in the last version of the guidelines. So I can just to give you hints and glimpses, but So we had this discussion when working initially, and for us. Our understanding, but I'm not a financial matter expert. I come from the tech subgroup. And so that's two different expert subgroups. So I hope I will convey it correctly. But please use the final guideline as reference if you need to. So my understanding is that from the AML, you do not need to have everything directly public on the public blockchain available. You can have some information that can be available, stored, off-chain or online. And so once that you take that, you have different way of doing it. Even in case where you are heavily using zero knowledge proof, then you have information that you keep. Zero knowledge proof are super, super strong proof of things. And so our understanding is, or at least our initial understanding, but we are reviewing again because people are worried. So we always fear that we have missed something, but we're doing the job again. But our understanding was that we could keep, and so request people to keep some information off-chain proving what they have done. And so that what was written on the blockchain was, what, was stored outside. And so that the blockchain will keep the proof, the commitments, these kind of things, for example. Mm-hmm. But outside of the chain, you will keep the witness, the data, and so on. And all those will be the things that you will need to give the entity or the different parts to prove that you did the job that you had to do. So the idea is to say, we don't have to have everything on the blockchain. And so you can have, like we say, both work together and both have a very high level of privacy because you will have mostly a commitment and zero knowledge proof. And at the same time, a very high level of commitment and proof because all of them will be registered and can be proven that you did this exactly at that time because it will be timestamped by the blockchain. Sorry.
I'm really, really sorry to be evil god of timing here, but I know that we also wanted to take a few questions. So maybe to start with you.
Taking that Microsoft, thanks for moving forward. These guidelines are very important, right? For organization, in particular because the toolkit, the technology toolkit to address many issues is there, right? Most of the issues can be solved, right? To the large extent. So, but there's a big elephant in the room here that I'd like to get your comment on. But when you give this recommendation, they are given to, you said you should do and make sense, which assume there is somebody on the other side, which is the designer of the system, where you have a clearly identified controller who designed the system and so on, which leads to the question of enforceability. And as we know, look at Satoshi, it was just a paper, we don't know who's behind it, a few lines of code, and then it started. And therefore the question, the big elephant in the room is the enforceability. We started to see the trunk and the tail of that elephant, where don't go after validator, atomic bomb, not atomic bomb. But you have multiple questions about enforceability. First of all, to whom? I mean, who's the controller? Who's the issuer? What is the status of validator? Then there's a question, can we access this person? And then back to the atomic bomb, right, which is even gray shade of the atomic bomb. Today the market cap of Bitcoin is 2.5 trillion, right? If you go after that system, you create systemic risk. So by the time you have the network effect, people start to use it, financial value or critically important processes running on blockchain, you won't have the option to actually act because you could trigger a systemic crisis, right? So the central question for me is how do we ensure enforceability with that lack of clarity? It doesn't mean that recommendations are not good. They're fantastic when there's a central party, a firm, a company who says, I'm going to do this thing, and so you remind them, well, there are a few principles that you need to follow, right? So I would like to get your perspective on the enforceability.
Super fast, there is one part that is super easy. Anyone who decides to use all those blockchain for something, they are controllers, that's super easy. Okay, and if they are aiming for EU residents, then the DPA that will be, in charge of this organization can make a control and so on. That's the easy part. For the hard part about, minder, validator, and the group below, then yes, it's harder. Our conclusion was that it will be a case-by-case thing. And for now, yes, there are some things that are not so easy, and there was no, I will say, perfectly clear cut about, anything. But you cannot ignore the law. So if you are in Europe and you are using those, please do it in a clever way, because all those are also used by partners that are not in Europe, and they are completely free to use it as they wish. Okay, but if you are in Europe, take the extra step for your use to be compliant.
Thank you. Any other question? Yeah, please.
Thank you very much. It was very interesting to listen about that, and it feels like GDPR maybe with blockchain are really not best friends, I might say, because of different purposes of open blockchain that wants to be more open and more trust for people, and GDPR that protects, on the other hand, those private information. So what do you think, what kind of rule in GDPR is the most you think, in your opinion, hindering development of blockchain? Because I also think that the future is after like smart contracts or blockchains, and it's very easy and to have trust between parties. So is it like legal biases, or you think something else that you think really stop development of blockchain? Thank you.
Thank you so much. Yara, would you like to respond?
Yes, thank you for the question. And I'm a big GDPR maxi, to be honest. I love the GDPR, so I don't think there is necessarily any issues with the GDPR itself. It's about the interpretation of the GDPR, and particularly trying to fit the logic that was the pre-existing logic that you need a centralized entity into the application when it comes to blockchain in this case. And I think that's the main issue, because you don't have any real possibility to actually go after anyone, especially if you decide to go after validators and nodes. It doesn't make sense. So you actually need to go after the people that have the data and pose the real risks also for the data subjects. So for me, the GDPR, if the Omnibus proposal passes, yes, I think it would make it easier in a sense because of the changes in Article 4 and personal data. But also, we already have this logic in Recital 26, but even with that logic, there are guidelines, for example, and interpretations that are problematic for like a whole space, like a whole industry, which I think then we need to sit down and have conversations like this and figure out how to make this work, because that's the way. It's not just saying, yeah, that's what the GDPR is saying, therefore it doesn't work, that's the end. We actually need to find a way, because the GDPR can allow it. It's already visible.
Thank you. And then I think we had the lady in the back. Yeah, I think we will need to close, but taking the last question.
Hi, thank you very much. It was great. So I am from the Commission, Cryptography Unit in DG Connect. So I'm deeply sorry that we were not connected before. So I am from the technical department in DG Connected, and sometimes it is a bit forgotten, I have to say. And so I'm deeply sorry to hear that this open consultation has been opened with just one last question about the data protection. If we would have been involved before, maybe it would have been. I don't know which commission units, services you are in contact, but yeah, let's be in contact. Yes, we have already several activities that are post-quantumifying, transforming to post-quantum cryptography, blockchains, decentralized finance. So I think we really have to work together. And yes, I fully agree with some comments about the email, but I also agree with some comments about the fact that indeed the GDPR is of course agnostic, but I'm not really sure we can really continue with being agnostic on everything, on technologies that are so specific in the mathematics, in the implementation, and that are protecting us from enormous risks in the future. Because of the recent quantum breakthrough on decentralized finance, I think that we would maybe need, maybe in the next version of a guideline, to improve them a little bit and make them a bit more understandable for the audience and more practical also. So thank you. Let's be connected. I would be enthusiastic to work with you. Thank you.
Thank you so much. Thank you so much also for coming here, to our great speakers, and please do enjoy the coffee break and the rest of the conference. Thank you so much.